Good morning, everyone. Please take a seat. We're about to get started.
Good morning. On behalf of the Alexander Blewett III School of Law, I want to welcome all of you to this morning's oral argument before the Montana Supreme Court. We really appreciate having members of the community, law students, faculty, staff, judges, attorneys, and all of the middle school and high school students who have come today to listen. My name is Michelle Bryan, and I teach environmental law.
And I'm Anthony Johnstone. I teach constitutional law and legislation. I want to extend a special welcome to the students from Anaconda High School and Meadow Hill Middle School as well. There will be, this will be the one announcement, but after the argument there will be a Q&A where all students are welcome, no attorneys are welcome, with the justices. So if you're interested in talking with the justices, the high school and middle school classes will stick around, but law students are welcome too if they want to come down in front right after the argument. This is the case of Atlantic Richfield Company, ARCO, one of many acronyms you're going to hear this morning, against the Second Judicial District Court in Butte. It involves the interaction of federal and state environmental law around the site of the former smelter site in Anaconda. Michelle, can you explain how this case got started?
I would be glad to, Anthony. The story of this case reaches way back into Montana's early mining history. The Anaconda Copper Company built a smelter in the late 1880s through the early 1900s near the newly created town of Anaconda to remove copper from the ore being mined in Butte. While most of the smelter has since been taken down, the stack from the smelter remains a visible feature of our landscape today. As is often the case, this smelter brought a mixed blessing. It employed hundreds of workers, gave rise to the lovely community of Anaconda, and became a rich part of our state's mining history. In the height of its operations, the smelter processed upwards of 9,000 tons of ore per day by some estimates. On the other hand, the byproduct of the smelting released arsenic, ash, and other contaminants into the surrounding valley. There's actually a case that my students read from over 100 years ago that describes how farmers and landowners suffered damages to their livestock, crops, and vegetation. The company would later modify the stack in an attempt to reduce some of those emissions. Eventually, the Anaconda Copper Company would go on to merge with Atlantic Richfield Company, called ARCO, the defendant in today's case, and the petitioner who brought this particular appeal. The plaintiffs in this case are individuals that own land in the vicinity of the smelter site that has been contaminated by smelter emissions. They have sued ARCO under Montana law, raising claims like trespass, nuisance, and strict liability. Montana also has a special constitutional provision, the individual right to a clean and healthful environment. You may hear about this particular provision today as well. It also allows for a claim for environmental harm. Among the remedies that the landowners seek for their claims is a form of compensation called restoration damages. If the plaintiffs, the landowners, are successful at trial below, they could use these damages to get funds to help clean up their properties. ARCO argues that the landowners are barred from seeking this type of damages. Now we'll step back a little bit to 30 years in time when the federal government designated the property around the smelter site, including the landowners' properties, as a Superfund site under federal law. A federal law with a very long name. The Comprehensive Environmental Response, Compensation, and Liability Act, and you won't hear us say that again, we're just going to call it CERCLA. Under this law, which we will discuss more in a bit, the government has been overseeing a cleanup process for the smelter site. So an important part of today's argument then is the interplay between federal law under CERCLA and Montana claims raised by the landowners. Anthony, normally an appeal to the Montana Supreme Court, which is our appellate court, happens after a final decision in a case. We might imagine a judge or a jury deciding a winner or a loser after trial, but here the appeal is coming much earlier. What is that about?
Well, Michelle, the landowners
brought this case in the Second Judicial District in Butte. The district court in Butte originally held that the landowner's lawsuit came too late, that it was time barred by a statute of limitations. In other words, that they should have sued back when the original injury occurred or was noticed. That would have ended the case, but the landowners at that time appealed to the Montana Supreme Court. And the Montana Supreme Court in an earlier case, a couple years ago, reversed, holding that the injury that they were suffering to their property might be a continuing injury, so that it's not time barred, and they sent the case back down to district court in Butte to continue the litigation of the claims. Now, in preparing for trial, about a month or so before trial, or perhaps a little earlier, ARCO moved for summary judgment on several grounds, including that the landowners could not recover restoration damages under state law because those were preempted by CERCLA, the federal law. The district court denied the motion and then set the case for trial. Now, usually, when a trial court denies a motion for summary judgment that would end the case or part of the case, the parties proceed to trial and the arguments are preserved for appeal when the case reaches a final judgment. But in Montana, we have a kind of safety valve called the writ of supervisory control. It allows parties to take non-final orders up to the Montana Supreme Court that they otherwise wouldn't be able to take for correction in the midst of the case. As our colleague Larry Howell has written, the writ itself originated in the War of the Copper Kings in Butte at the turn of the last century. It was invented to allow the Anaconda Company to take cases away from the infamous Judge Clancy in Butte from correction by the Montana Supreme Court. It remained on the books for, interestingly, Anaconda's successor ARCO to bring this case back up to the court before the trial finished. Now, there's no problem with corrupt judges in the War of the Copper Kings anymore, but the court still prefers to use the writ to solve big issues in a case before it gets too far along. That's what the court is doing here. So if it turns out that the landowner's state restoration damages claim is barred by the federal CERCLA law, it will save everyone time and money at trial. But if it's not barred, then the trial can move ahead on the claim. Now, Michelle, you mentioned CERCLA. Can you tell me what that is?
I'd be glad to. CERCLA is actually a relatively recent environmental law compared to some of our other environmental laws. Congress created it in 1980. The Environmental Protection Agency, the EPA, administers its Superfund program, sometimes in cooperation with states and tribes, to help clean up hazardous sites in our communities. CERCLA authorizes EPA, states, and tribes to clean up these sites, and as my students will tell you, environmental law is chock full of acronyms. So I'm now going to take you on a little adventure through the acronyms associated with CERCLA. You've already heard CERCLA and EPA. Keep a watch out for a few others as I explain more about this law. To qualify for cleanup, a site is listed on a national priority list for Superfund sites. You are probably familiar, if you live in Missoula, with the Milltown cleanup in our own community, and the government is also considering the possibility of listing Smurfit Stone Pulp Mill as a potential cleanup site. On listing a site, EPA tries to identify generators, transporters of hazardous waste, and owners and operators of hazardous waste sites. These people or entities are considered potentially responsible parties. Can you guess that acronym?
PRP?
PRP. They are asked to conduct and or pay for cleanup studies and activities. ARCO is a PRP in this case. Now I'm going to tell you about 4 steps leading up to the cleanup, which involve acronyms. Think about the steps like this. Step 1, investigate. Step 2, decide how you're going to clean up. Step 3, design that cleanup. Step 4, act, do the cleanup. Step 1 is called the RIFS, Remedial Investigation and Field Study. This is where the data is collected about the site and its environmental hazards and where different possible cleanup approaches are considered. Within the site itself, it may be broken up into operable units. What do you think operable units is? abbreviated to.
OU? That doesn't seem that long. Why
OU,
acronym?
that's a really short, little baby acronym. So there are OUs within the bigger cleanup site. Step 2, decide. A record of decision is issued by the agency choosing the cleanup method for each OU. The reasons are set forth in this ROD. There is public participation leading up to the selection of the cleanup method and the ROD, and parties can challenge the ROD. Step 3, RD, remedial design. If you think about the analogy of building a house, the remedial design is kind of like drawing up the architectural plans. It's the careful, detailed plans of how the cleanup will occur. And step 4 then is the RA, the remedial action, which starts the actual cleanup at the site. To return to our analogy, the RA phase is like the building of the house. Those responsible for the cleanup get all the materials they need and follow the plans developed in the RD phase. This is when you see construction equipment operating on the site conducting cleanup. The ultimate goal under CERCLA is to restore the site to productivity so it can once again add to the economic, social, and ecological value of our communities. On the smelter site at issue in today's case, EPA approved cleanup that includes cleanup of soils, surface water, and groundwater until they reach certain acceptable levels of arsenic and other contaminants. The landowner's lawsuit asks for restoration damages that would allow additional cleanup beyond those acceptable levels set by EPA. Just a little bit more on CERCLA, I apologize. It has specific provisions that govern how individuals may sue over issues involved on Superfund sites. One provision we could call a challenge provision. It specifies when and how parties can challenge EPA's CERCLA cleanup decision. A second provision is called a savings clause. It allows individuals to bring their own separate state law claims in certain situations. It's called a savings clause because it saves space for the state law claims to coexist in certain situations with the CERCLA cleanup. The final provision is a citizen suit provision. It allows individuals under certain circumstances to sue under CERCLA, that federal law, if they believe companies or the EPA are failing to follow the law. The parties today dispute whether and how these provisions apply. So for fun, we could put all these acronyms to good use. Let's say that ARCO argues under CERCLA it has no liability beyond the EPA's ROD for each OU. Each one which was based on a careful RIFS and are being implemented through the RD and RA. Plaintiffs disagree. Easy peasy. So Anthony, a big part of ARCO's argument is based on preemption. Can you tell us about this constitutional concept and why ARCO maintains it prohibits plaintiffs' claims?
Why, I'd be happy to, Michelle. This is where the Constitution comes in. The federal Constitution provides for enumerated powers. For example, the Constitution gives Congress power to regulate commerce among the several states. Now, even pollution counts as commerce, and CERCLA is an exercise in part of Congress's commerce power. Where Congress enacts laws within its constitutional powers, like CERCLA, the Constitution says they shall be the supreme law of the land, and the judges in every state, including these justices, shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. So in other words, the federal Constitution trumps both the state Constitution and state laws, as do federal laws. So CERCLA is supreme law over Montana's common law, and even Montana's constitutional environmental clean and healthful remedies. If there is a conflict between the state claims and CERCLA, CERCLA prevails. Now, whether there are conflicts here, and that's basically what this case is about, largely depends on whether plaintiffs' state claims may be read as a challenge to a CERCLA cleanup under the text of the CERCLA statute. I think it's section 113H. ARCO says the state claims are such a challenge because it will interfere with its federally required cleanup under CERCLA. As a matter of fact, they say there will be problems with a dueling cleanup, digging up polluted ground to establish plaintiffs' restoration damages. And as a matter of law, because of the broader policy purposes behind CERCLA. Because of this, and other provisions like the saving clause and citizen suit provisions, ARCO argues preemption, that the supreme federal law preempts or blocks the operation of state law. That preemption can be express, such as if landowners' claims are a challenge under the text of CERCLA by its terms, or preemption could be implied due to the impossibility of ARCO in complying with both CERCLA and state law or serving as an obstacle to the accomplishment of CERCLA's federal purposes. Now, the landowners argue that it doesn't conflict, that it complements CERCLA. They are claiming that the property owner's claims are consistent with CERCLA's purposes remedying pollution. Beyond this, CERCLA's text is somewhat unclear as to how it even applies to state courts and state claims in these situations. Both sides will point to the text as well as the legislative history of the statute and various cases decided under CERCLA by other courts. There are also going to be some amicus curiae, some friends of the court. The United States is appearing here on behalf of the EPA, and the Montana Trial Lawyers Association and the Montana Environmental Information Center are appearing on behalf of the landowners. There are other amici too, but the court has allowed both the United States and the Trial Lawyers and Environmental Group to argue in support of their respective sides. So now, Michelle, what have been lawyers' roles in this case up to this point?
Well, the parties and the lawyers for amici have written briefs that they've filed with the court arguing their position. And what you might not know is that not every appeal gets an oral argument. So it's after reading the briefs in this case that the Montana Supreme Court determined it had questions and would like to hear oral argument from the parties. Each year it selects a handful of these appeals for oral arguments. We're very lucky to have them here today. At today's oral argument, the attorneys are going to follow a very specific format where the petitioners, ARCO, argue first since they brought this petition. The respondents, the landowners, will argue next, and then the petitioners will return to the podium to offer rebuttal. Each side must follow strict time limits. Today, each side has also agreed to share time with the attorneys for amici, so you'll see and hear from them as well. As you will soon observe that during oral argument, the justices can and will interrupt the speaking attorney at any time with questions. And Anthony, what happens once oral argument is concluded?
Well, after hearing the arguments, the justices will meet in conference to discuss the case, vote on which side had the better arguments under the law as applied to the facts, and assign opinion writing duties. If the justices are unanimous, there will be one opinion written by one of the justices for the whole court. If the justices disagree on the outcome, whichever outcome that is supported by at least 4 justices in this case will prevail. And one or more justices may write separate opinions, either concurring or agreeing with the result, but for different reasons, or dissenting or disagreeing with the result. Now, because this case involves a question of federal law, regardless of the result, the losing side may petition to the Supreme Court of the United States, which has the last word on the meaning of CERCLA as federal law, although the Supreme Court only hears about 5% of cases lawyers bring to it. So in most cases, state Supreme Courts have the last word, even on important questions of federal law, such as the one we'll hear about today. So let's get started. Because ARCO, as I said, lost in the court below, it will argue first and last. ARCO is represented by John Rauschway. The landowners, or the counter-petitioner, will argue second, and they're represented by Justin Stolpus. On ARCO's side, for the United States, Matthew Oakes will argue the EPA's position. And for the Montana Environmental Information Center and the Montana Trial Lawyers Association, on the landowners' side, Dominic Cossey will argue for them. So this is an official judicial proceeding, so please remain silent and seated during the arguments. Turn off your mobile devices, remove your hats if you have any, preserve the dignity. This is now a courtroom. The clerk of the Supreme Court, Ed Smith, will begin the proceedings shortly. Acting Chief Justice Beth Baker will introduce the court. And Michelle and I would just like to conclude by thanking the Montana Supreme Court for sharing these important arguments with us here at the University of Montana. And thanks to all of you for joining us today. And remember, students, you're welcome to stay after for Q&A with the court. Thanks, everyone.
All rise and give your attention. The Honorable Justices of the Montana Supreme Court. This court is now in session.
Morning, everyone. Is this on? Can you hear me? There we go. I'd like to welcome all of you to these proceedings of the Montana Supreme Court. You probably noticed that I'm not Mike McGrath, who is our Chief Justice. I'm Beth Baker, serving as acting chief today because Chief Justice McGrath has disqualified himself from proceeding in this case. And I want to introduce the justices and judges who are sitting with us today and the other court staff. First, I'd like to start with our clerk of the Supreme Court, Ed Smith, who will be marshaling the argument today. And then to my far right is the newest member of the Supreme Court, Justice Dirk Sandifer. Immediately next to him is Judge Jim Manley from Polson, who is sitting in for the Chief Justice today, and Justice Mike Wheat. To my immediate left is Justice Lori McKinnon, and then Justice Jim Shea, and on the far end is Judge John Kutzman, who is sitting in for Justice Jim Rice, who also has recused himself from today's case. I want to thank the university for hosting us today. It's always a really nice opportunity for the community to see the court in action and for us to see the communities we serve. And I especially want to thank the law school professors Johnstone and Brian for doing a tremendous job of introducing today's case. Today we'll be hearing from Atlantic Richfield, and Jonathan Rauschway will be arguing for Atlantic Richfield. We also will be hearing from Matthew Oakes with the United States Department of Justice. Arguments for the landowners will be from Justin Stelpus, and then the Amicus Montana Trial Lawyers Association will be Dominic Cossey. So with that, we are ready to proceed in the matter of case number 16-0555, the Atlantic Richfield Company Petitioner versus the Montana Second Judicial District Court, Silver Bow County, the Honorable KATHERINE BIDEGARAY. Are counsel ready to proceed? Mr. Rauschway.
Good morning, and may it please the court. The environmental cleanup has been underway at the Anaconda Smelter Superfund Site for over 30 years. The United States EPA and the Montana State DEQ have been directing that cleanup under authority of the Federal Superfund or CERCLA statute. And through the CERCLA process, EPA, with the participation of the public review and comment, and the approval of the state of Montana, has chosen remedies for the Anaconda site and continues to implement and refine those remedies to this day. The plaintiffs are private landowners on the Anaconda site who are dissatisfied with the remedy that EPA has chosen and have brought this lawsuit to perform their own remedy. Their remedy would be a far-reaching one that would affect far more than just their properties, but also affect the properties of their neighbors and others in the community who are not parties to this lawsuit. None of this is disputed, nor is it disputed that if the plaintiffs cannot perform their restoration remedy, they cannot obtain the restoration damages that they seek. So the ultimate question in this appeal is, who gets to decide environmental remedies at Superfund sites? We say it ought to be federal and state regulators under the legal framework that Congress created. They say it can be private litigants if they prevail in private lawsuits in state court. But the answer is clear. Congress decided that EPA would be the one who would decide environmental remedies at federal Superfund sites.
Counsel, if we accept your position in that regard, then in Superfund cases like this one, then the private landowners, citizens of the state of Montana, have no remedy except the remedy that's imposed by the EPA. Is that correct?
No, That's not true, Justice Wheat. They have a number of common law remedies that we're not challenging here. And this might be a good point to make that clear. CERCLA does not bar claims for personal injury. If any of these plaintiffs claim that they're sick or injured because of historical contamination on their properties, and none of them have claimed that in this case, but if they did, CERCLA would be no bar to those claims. CERCLA is also not a bar to nuisance and trespass claims for individual property damages like diminution in value and loss of use. If plaintiffs can prove that their properties have diminished in value or that they have some kind of compensable lost use on their properties, they can bring those claims, and they have brought them in this case. And we're not arguing that CERCLA bars those claims.
So the only claim that we're dealing with here is restoration damages.
That's
and you
correct.
think that that's preempted by the CERCLA statutes?
That's correct, Justice Weed. And just to finish out that point, plaintiffs also have a remedy built into the CERCLA statute that Congress expressly created for landowners like them who are dissatisfied with the remedies EPA has selected. And that's called a CERCLA citizen suit. It's provided under the statute. And at the end of the cleanup, they can bring this claim in federal court, and they can tell a judge that they think that the same kinds of claims they brought in this case, that they believe the remedy is insufficiently protective, that it's still dangerous to human health, all those sorts of things. And if they can convince the judge of that, the judge will require EPA to select a more stringent remedy, and EPA will require ARCO to pay for it.
And are you talking about the judge as a federal judge or a state judge?
Citizen suits are provided under the CERCLA statute itself, for which there is exclusive federal jurisdiction, so that would be a federal claim.
Okay.
Counsel, if the remedy proposed, your position is that the remedy the landowners are proposing is in conflict with the CERCLA remedial plan. If it were not in conflict, would you concede that restoration damages would be appropriate?
Well, it depends on what you mean by conflict. Certainly they have to get EPA's approval for this. If they were to get EPA's approval for all or some part of their restoration plan, that would certainly cure the problems under Section 122. That approval would have to be a little more formalized for it not to be a challenge to the remedy. It would have to be incorporated into the Superfund remedy for the site, and it would have to go through the CERCLA process.
But CERCLA allows state actions to proceed.
It does, generally. CERCLA is not a statute of general preemption. And it's important to remember that CERCLA claims happen all the time at non-Superfund sites. And most of the cases that the plaintiffs have cited are those sorts of situations. You can assert a CERCLA claim after a voluntary cleanup, after a cleanup that's required by a state or local government, and you're free to assert state law claims alongside that. State law claims that are CERCLA analogs like CERCLA here in Montana, or common law claims like trespass and nuisance. And the only restriction that the statute ordinarily puts on those kinds of claims is that you can't get a double recovery for the same kinds of costs. But that's a different question from whether you can bring a claim that challenges EPA's remedy under 113 and our related preemption arguments.
Although, Mr. Rauschway, to follow up on that question, we're here reviewing a summary judgment order, and I'm wondering, as I read through the cases and through the briefs, whether there are any potential fact questions that may bear on this question of interference with the remedy, innocent landowner, the effect on ARCO's financial ability to pay. But a lot of the cases talk about whether the plaintiff's plan would exacerbate contamination or impede the cleanup being done by EPA, affect, alter it. Are there fact questions that remain to be resolved here?
Not with respect to 113. That's a issue that goes to the court's subject matter jurisdiction. So even if there are factual disputes there, the court is empowered to resolve those itself to satisfy itself of its jurisdiction.
Well, counsel, as it pertains to 113, though, and I know that you've cited a case from another jurisdiction, but it does specify no federal court. And I mean, it's just a fundamental rule of statutory construction. We don't insert what's been omitted. How is your argument on 113 not asking us to insert no federal or state court?
Sure. Well, the Ninth Circuit has spoken to this directly in two cases. The first one is the Fort Ord case. The second one is the ARCO remediation case. And the Ninth Circuit explains that Section 113H has to be read together with Section 113B, which provides for exclusive federal jurisdiction over all controversies under CERCLA. And the Ninth Circuit has held that the definition of an impermissible challenge to a remedy, something that relates to the goals of the cleanup or seeks to alter the method of cleanup, et cetera.
No, and I understand. I mean, like I said, I read your cites to the Ninth Circuit cases. Beyond that, is there any binding authority that has inserted the language, no federal or state court?
Well, no binding authority. There's no U.S. Supreme Court authority on this statute. And while we think the court should find the many Ninth Circuit cases to be persuasive, the court is not bound by those, even though this is an issue of federal law. But this is not just a creature of the Ninth Circuit. There are those two cases that reach this issue expressly and talk about the interaction between 113B and 113H. But courts across the country, including the 10th Circuit, district courts, have all recognized that if you bring a claim under the guise of a state law cause of action and it actually challenges the EPA's remedy, that isn't necessarily a federal claim. And it really doesn't matter what the label is on the claim. It could be a nuisance claim, it could be a statutory claim, you could call it whatever you want. But if the remedy is founded, or excuse me, if the cause of action is founded on performing an alternative remedy at a Superfund site, it's barred by Section 113.
Counsel, the federal consensus seems to be that a prohibited challenge is a claim that, whatever its state law characterization, is a claim that seeks to alter, delay, or stop an EPA-mandated cleanup, which then, in my view, turns in each of these cases on what the factual impact is or isn't on the EPA cleanup. I don't understand on the factual record here how it is that ARCO and the United States government as Amicus assert that this proposed remediation plan under the state law remedy alters, delays, or stops an EPA-mandated cleanup that, from what I can tell, is substantially complete with not much left to do.
Well, Justice Sandefur, there's a lot built into that question. First, the standard is broader than you articulated. It's not, challenges are not restricted to just those that would alter, delay, or stop the cleanup.
Tell me what the challenge is here that you think renders this state law claim defective.
Well, first, it satisfies the broader prophylactic standard of something that seeks to improve on the cleanup, alter the method, or relate to the fundamental goals of the cleanup. So that's how it fits the statutory definition, as numerous circuit courts, not just in the Ninth Circuit, but elsewhere, have defined what a challenge really consists of. And that
what
makes
authority
sense.
says that a state law remedy can't supplement or go beyond the level of remediation that is being accomplished by the EPA-mandated plan?
Well, that is exactly what a challenge is that seeks to improve on the cleanup. So that's how it satisfies that definition here.
I'm asking you what the authority is for the proposition that you've just stated, that a cleanup that goes beyond what the EPA-mandated program is a challenge that's prohibited or precluded by federal law.
Well, that standard has been articulated and reaffirmed in probably half a dozen Ninth Circuit cases that we've cited in the brief. But if you dig deeper than that, just what those cases say, there's reasoning behind that, and there's 2 points I'd like to make. First is the standard is broad because it's intended to be prophylactic. It's intended to head off the kinds of inquiries that we're having right here. You know, does this really conflict? Would this really make it worse? Those are decisions that Congress has given EPA.
I understand that. What I'm asking you is, where's the conflict?
Okay, well, there is a conflict. Even if the standard were, it's only a challenge if the remedy conflicts with what EPA is doing.
That's what I'm asking.
There is a conflict.
What is the conflict?
Sure, I'll start with the soils remedy, because they have both a soils remedy and a groundwater remedy. In the soils remedy, they propose to tear up the top 2 feet of all these residential properties. EPA's cleanup has already cleaned up about 25 of those properties, including bringing in new soil and revegetating them. Their cleanup would literally undo what EPA has already done. Their cleanup would propose to extend this top 2 feet removal to pasture properties. EPA has made the express determination more than once in the course of its regulatory determinations and once in response to a request from Atlantic Richfield, to remove soil from those properties, and EPA has said no, those properties are better left undisturbed. They have an established vegetative cover, and if you remove that, it would increase exposure to contaminants in the subsurface and increase dust problems. So this is...
But aren't those the same problems that EPA had to deal with when the remediation that has taken place started in the first place?
Yes, and that's precisely why it's a challenge. The plaintiffs are trying to improve upon the cleanup and do a different cleanup, and a cleanup that in fact is different and conflicting with what EPA has done and is still doing at this site. Let me give you another one on the soil side. The plaintiffs have offered a number of possible repositories where they want to take this soil. The latest iteration seems to be they want to put it in the former Opportunity Ponds, which is adjacent to their community, and that's where all the soil went from the cleanups that Atlantic Richfield did, not just in the Anaconda area, but also here at the Milltown Dam. Some of you may remember that was a very difficult project to get that soil to be revegetated. It took a number of years and a lot of soil science to get that to work, and it's been a success. It's now lushly vegetated, and there's, the biggest problem there now is controlling herds of wildlife on it. If they want to remove 500,000 tons of soil and put it there, it would involve tearing up that revegetative cover too. So that's the soils piece. I also would like to tell you how the groundwater piece would conflict. That's an easier case. They want to build miles of underground walls, upgrading of their property that will affect the flow of groundwater, not just for their properties, but for the entire community. And sure, they say, oh, it's supposed to be a permeable barrier that won't divert water, but that's awfully simplistic, and that's not how these things work. These are the kinds of decisions that are supposed to be made by EPA and its experts, not by plaintiffs and their hired experts. And there's numerous things that could go wrong in the course of constructing those walls, maintaining those walls, that would change radically EPA's understanding of the groundwater model at this site that it's been working on for 30 years. So even if the standard were a direct challenge, that standard is met here.
So if there are approximately 90 separate property owners represented by the plaintiffs, and if the EPA ARCO remedy proposes to only clean up partially about 24 of those properties, for the other 70 property owners, aren't they denied their common law nuisance restoration damages that Montana law affords them?
They have remedies, they just have different remedies. To answer your question directly,
Well, they don't have
would they have a
restoration
restoration claim at a non-Superfund site?
But would
they
you-
don't have it here? Yes, of
You
course that's
deny
true.
them their restoration damages that Montana law would guarantee them, wouldn't you?
That's correct, but that's how the Supremacy Clause works. Federal law has to prevail over state law, even if it's a constitutional claim or based in a constitutional
Why
provision.
wouldn't, for those other 70 property owners, that be an additional remedy that does not conflict with the EPA remedy?
Well, it does conflict for the reasons that we just described, for the remedy that they need to perform in order to obtain those damages. But Justice Manley, let me reach back into your question, into the premise for a moment. As I understand restoration damages in Montana, it's designed to effectuate the right for a clean and healthful environment under the state's constitution. And that's the same goal that CERCLA has. CERCLA's wording is protective of human health in the environment. That's the formulation used in the CERCLA statute. It's all over the statute. So the question is not that these people are left without a remedy or they're left unprotected. It's simply that it's a different legal standard and a different process, and that makes all the sense in the world. You have state remedies at state sites, and you have federal remedies at federal sites.
Well, counsel, as I understand it, the goal of CERCLA is to restore the property to its pre-contamination state. Am I correct in that?
Generally.
Okay, generally. And so we're dealing with people who have lived in this community of opportunity for a long time. And as I've read through the briefs, the pre-contamination levels of arsenic and lead are well below what EPA said they should be brought to. And without going into all of those numbers, you would agree with that, wouldn't you?
Generally, the action level that EPA has selected
Okay,
for
so-
soils is not to take it back to
Right.
pre-industrial state.
EPA's cleanup model, if you will, does not restore the property to its pre-contamination state, does it?
Well, it depends on what you mean by restore and pre-contamination. First of all, this is sort of a unique community in the sense that there was contamination from the smelter there before there was even a town. So, that's an unusual case. It's not the ordinary situation in a CERCLA cleanup. But CERCLA does not try to take us back to pre-Columbian conditions. It tries to take us back to a condition that's protective of human health and the environment.
Well, wouldn't that be pre-smelter conditions?
No, not necessarily pre-smelter conditions. I mean, there are traces of human industrial activity just about everywhere, certainly in the Western world.
No, but here we're talking specifically. I mean, we're not, you've got a 6 to 16 parts per million background of arsenic that's natural, that there seems to be no dispute there. That's according to your expert. But what we are talking, nobody's disputing, this didn't come from some paper mill in Wisconsin. I mean, this is the smelter. So aren't we talking about, when we're talking about restoration to pre-contamination, it's before it was contaminated by the smelter?
Well, first of all, the background levels in this area are hotly disputed. And I won't go into what our expert says and what their expert says, but I will point out that the Montana State DEQ did a statewide background study of arsenic in all of Montana. And you can go online and look at this. It's all on the web. And they determined that the statewide statistical measure was about 40 parts.
40 parts per million.
Correct.
That's still below 200 parts per million.
Well, let me make two very quick points because these are extremely important. That includes all of eastern Montana that has 0 or single-digit levels of arsenic. There's a whole lot more arsenic in mountainous areas in the western parts of the state where it's mineralized because that's where the mining was and that's where the arsenic takes place. If you go online and look at their results, the results in Deer Lodge County are in the 80s and 90s and 100s. So this notion that we have to take it back to 0 arsenic or arsenic in the single digits is not what would exist there naturally. This arsenic came from the ore that was smelted in Butte, and it's there in the native rock in Anaconda as well. But to get back to the original premise here, CERCLA doesn't necessarily try to take us back to pre-industrial conditions. It tries to take us back to a condition that is clean and healthful or protective of human health and the environment, however you want to phrase it, under sound science, and there's a vigorous and rigorous process to make sure that happens.
Counsel, if I could ask you, the issue here is whether in fact this is a challenge to CERCLA, isn't that correct?
That's one of the issues, Your Honor.
If it is not a challenge, then I go back to my first question. Do you concede that restoration damages would be appropriate if it were not a challenge?
If the court decides that their restoration claim is not a challenge, then CERCLA 113 doesn't bar their claim. That's certainly part of the statutory analysis.
So is the issue of whether the remedial plan proposed by the landowners, whether that's a challenge, that's a factually driven inquiry, isn't that correct? It
is a factual inquiry, but it's one that the court should make because it goes to
that's my concern
subject
here.
matter jurisdiction. But let me quickly make a point on Section 122, which is the other CERCLA section we relied on here. That does not depend upon the court finding that their plan is a challenge. That section requires only that the plan be approved by EPA. And there's no factual dispute that this plan has not been approved, and they've filed papers with this court that says they have not and will not approve this plan.
Well, counsel, just on that point, the whole issue here, like as you've noted, there are other damages that are available to the plaintiffs that are not preempted, and there's no question are not preempted, correct?
Yes.
So, and the only reason that restoration damages are preempted is because we adopted the restatement that says that the plaintiffs have to express a genuine intent to pursue restoration. And that so isn't that, and this kind of goes back to Justice Baker's question about questions of fact, we've talked about that being, in terms of the genuine intent, being a question of fact. If there's no question of fact that there is a genuine intent, or for that matter, what's the problem with they're putting it in a trust anyway? And that's an element of damages that they just present to a jury and let a jury decide whether they genuinely want these restoration.
Well, I think we would undoubtedly have a right to argue to the jury that the plaintiffs could not, as a matter of law, conduct their restoration plan because EPA has not approved it. But this is an inseparable component of restoration damages, and this has never been disputed in the case, that those kinds of damages in excess of diminution in value can only be awarded if the plaintiffs are really going to conduct their cleanup. And this court has gone on at length in cases starting with Sunburst, followed by Lampe and McEwen, that the whole rationale behind allowing those kinds of damages is because they will be used for cleanup. Otherwise, it would be an impermissible windfall if the plaintiffs were simply to pocket those damages. So I don't think you can separate out the components of performing the remedy and the actual monetary award for this type of damages. But even if you did, it would still be a challenge. And I would direct the court to the 10th Circuit's case in GE versus New Mexico, where the court dealt with a very similar claim for restoration damages for an aquifer under common law, nuisance and negligence, and they held that even if it were purely monetary and they didn't use the damage award there, it would still be a challenge because the plaintiffs couldn't, I think in the words of the 10th Circuit, achieve indirectly through the threat of monetary damages what they couldn't achieve directly through injunctive relief to actually perform a different kind of cleanup there.
If they were able to finance it through some means other than making your client pay for it, would it still be a challenge?
It would certainly still, they would need to comply with 122 in order to get it approved by EPA before they could perform it.
And according to you, EPA will never approve that?
Certainly not in its current form. They won't approve it, and they won't approve it because, as they've explained in detail in the Amicus brief, it conflicts with and would negate a lot of their efforts, ongoing efforts to clean up the site.
So they're stuck with more arsenic on their property than they want forever?
Well, again, these folks didn't buy pristine properties. They bought properties with arsenic already on them. If they don't meet the EPA cleanup standards now or as revised in the future, then no further cleanup will take place unless they comply with the CERCLA process and EPA incorporates that into their cleanup plan.
Counsel, I know that your time is up, and I don't know whether we're going to extend time or what, but following up.
He's just using Mr. Oak's time, so he's still within his 40 minutes.
Okay, sorry, Mr. Oakes. Getting back to section 122, and for the landowner's proposed remedy here with restoration damages, you say has to be approved under 122. Is that because you claim that they are potentially responsible parties under the statute?
Yes, the statute applies only to potentially responsible parties.
Right, and if we determine that they're not potentially responsible parties, irrespective of your argument to the contrary, then 122 does not apply.
Correct. Correct.
Thank you.
Okay. I'll reserve the rest of my time for rebuttal. Thank you.
Mr. Oakes.
May it please the court. My name is Matt Oakes, and I represent the United States. The focus of CERCLA is on cleaning hazardous waste. And
You're not coming through very clearly.
that better?
That's much better.
There we go. The focus of CERCLA is on cleaning hazardous waste. And the two statutory provisions primarily at issue here, 122E6 and 113H, are tools that Congress has given EPA to help ensure that litigation and conflicting cleanup requirements don't undermine a cleanup at a Superfund site. And
well, counsel, let me interrupt you before you go any further. Don't the people who own this property have a right to seek a remedy that will restore their property to a state that exceeds the standards established by the United States government through EPA?
Congress created a cleanup process. It created that cleanup process through CERCLA. And through CERCLA, specifically in Section 121 of CERCLA, Congress explained the nature of the cleanup that needed to be implemented at the site. And the nature of the cleanup that Congress said needed to be implemented was that EPA needed to coordinate its cleanup with federal authorities, with local authorities. It needed to ensure that the cleanup met all applicable, relevant, and appropriate federal and local requirements. It needed to be sure that the cleanup met health standards, it met risk standards. But it did not create a remedy, in CERCLA at least, that ensured a cleanup to some kind of pre-contamination background level. So to the extent that that's your question, the answer is no. That's not the scheme that Congress created. Now, if your question is, does Montana have a remedy that would go beyond that? The answer is, it might. I'm not sure. That's not why I'm here today. What I am here today to argue is that to the extent that a proposed remedy is a challenge to EPA's remedy, conflicts with EPA's remedy, that proposed remedy is preempted. Now, it's preempted in different ways and for different aspects of that remedy, and that's something I'm prepared to talk about. But if you're asking, does a landowner have a right to take their property back to a pre-contamination state under CERCLA, the answer is absolutely not. That's not how CERCLA works. That's not the nature of the cleanup standards that we've implemented. We look to
So
achieve...
let me interrupt you just for a second there. So if under Montana law and the Montana Constitution, which provides for a clean and healthful environment, and under our common law allowing for restoration damages, that would all be preempted by the federal statutes?
It depends on the nature of the cleanup that's proposed. So here we have a restoration damages remedy, and when we look at the particular nature of that remedy proposed, aspects of that remedy conflict with EPA's remedy. And so to the extent that there's a conflict, a challenge, there's a preemption. If there was a remedy that was not a challenge to EPA's remedy, if there was a further remedy that did not conflict with EPA's remedy, then it wouldn't be preempted.
Right, and we're just sort of plowing the same old ground here that we just argued with. The remediation plan proposed by the plaintiffs in this case, from ARCO's position and from the United States government's position, conflicts with the EPA's cleanup program.
That's correct.
And it conflicts with it because they want to, first of all, they want to put in this barrier that does something to, I guess, clean up the groundwater around their properties. That's a conflict, right?
Well, what I'd say first, I'd like to give some context to that, because the proposed cleanup here is something that EPA, the extent of EPA's review of that cleanup is the documentation in this case. We haven't had an opportunity under 122E6 to review that plan, to ask questions, and get the kind of detail that we'd like to know the extent and scope of a potential conflict. Aspects of that cleanup don't conflict and aspects do.
Well, excuse me, let me interrupt just for a second there. Litigation has been going on here for quite a while. And
That's
you're
correct.
telling me you haven't had a chance to sit down with the landowners here and review their remediation plan?
When EPA implements a cleanup at a site through a record of decision, there's 5 records of decision at this site. Those records of decision take thousands of pages. The actual implementation, the remedial design, the remedial action process takes hundreds, sometimes thousands of pages. There's a lot of detail. You know exactly where the cleanup's going to happen. You know exactly who's going to be doing it. You know how that's going to interact with the rest of the remedy. And what EPA is trying to do at a site like this is to coordinate. We're trying to make sure that the standards are met, that the health-based standards are met, and we're trying to ensure that the remedy's moving forward and that the PRPs are implementing that remedy. Now, our ability to do that is severely compromised, and it's undermined if there were 100, 200, 300 different separate property-specific cleanups going on. So what we need to do is we need to have those cleanup plans come into EPA and review them and see what exactly it is they're doing. Not generally what they're doing, not 30 pages worth of an expert report, but what exactly it is that they're doing at the site and how that interacts with our site. Now, given the general information that we have here, we do know that there are some aspects of this plan that do conflict with what EPA plans on doing. And the examples that we've given, you know, I'll give more detail in one particular example. So the groundwater beneath opportunity right now meets all federal and state drinking water standards. In other words, you can drink the groundwater. The remedy is considered protected with respect to that groundwater. And that's the ultimate goal. EPA wants a protective remedy that protects human health and the environment. Up gradient of opportunity, there's arsenic-contaminated groundwater. There's a plume of arsenic contamination. And that plume of arsenic contamination is currently not migrating toward the groundwater in opportunity. In other words, the status quo is protective, but it's delicate. The reason EPA's experts think that that groundwater isn't contaminated by arsenic is because historically, opportunity was built on lowlands. They were built on swamplands. And historically, those swamplands were drained through a series of drain tiles. So there's a series of drain tiles pulling water away from opportunity toward Willow Creek. And south of opportunity is the plume of contaminated groundwater that right now is not migrating toward the drinking water. Now, if you start digging trenches between those two areas or alongside of those areas, you're changing the underground topography. So what EPA is doing right now is they're monitoring that plume. If that plume starts to move toward opportunity, then they're going to change their remedial approach, and they would do something different to try to stop the migration of the plume. But now we're monitoring, because now the status quo is protected. If you change the status quo by digging trenches, by installing barriers, even if they're permeable, it's relatively new technology, and we don't know how that's going to affect a remedy that's currently protected in a delicate state. So that's an example of one thing that's proposed through this restoration damages remedy that could cause a dramatic negative impact on the groundwater and opportunity.
Mr. Oaks,
And that's why we're monitoring.
are these the kinds of jurisdictional facts that Mr. Rauschway was suggesting need to be decided by the court to determine this conflict issue?
Well, so the nature of there's two separate terms, legal terms that matter here. There's conflict, and conflict goes to the preemption argument that we made, and then there's challenge, and challenge goes to the nature of 113H. And when the question is, what is a challenge and what isn't a challenge? What is a challenge is something that, you know, we've determined as EPA that there is a challenge here because aspects, even though we don't know all of the details of this cleanup, aspects we know would lower the cleanup levels that EPA set and determined were protective, would change the volume of dirt and the depth of dirt that's excavated at sites, would change the location that dirt is deposited. And you know, that's another example of having room and space to properly dispose of and store contaminated materials matters. Right now, there's disposal sites that are relatively local. And there's limited volume. And so if you have another cleanup that other landowners are doing independently, and they fill the capacity, the disposal capacity, that could impact EPA's cleanup in an indirect way. And so your question is this a question of fact or a question of law? Is this something this court determines or that's determined below on remand?
Or was it determined below? Did the district court find these jurisdictional facts in denying summary judgment?
I don't believe that the district court assessed the nature of the challenge to a sufficient degree. I think that the court could determine that a challenge was present based on the information available. I think this court could make that determination. I think that the lower court on remand could look at a much greater level of detail to make that determination.
So you're suggesting that we look at the conflict in the soil remedy proposed as well as the groundwater remedy proposed by the landowners in the record and make that decision here?
I think there's a tiered process. I think the first step is that landowners need to submit their proposed cleanup plan to EPA under 122E6 for review and authorization.
I thought they had submitted a plan that was specifically rejected by the EPA.
They have not.
That plan was rejected by EPA itself when they considered it, isn't that correct?
They have not submitted a plan to EPA under 122E6 for review.
Right.
EPA has not had the chance to ask questions about how that plan would be implemented. EPA's only opportunity to review that plan has been in the course of this case.
I understand. But my understanding from reading through the briefs is that this permeable wall was something that was considered by EPA and rejected. Is that correct?
That is not correct. EPA considered a permeable wall, not the permeable wall that's been proposed in this plan. It was a different wall. It had different parameters.
Okay, well, let me follow up then on 122 again, the same question to you.
I'd just like to say I'm arguing on borrowed time, so I don't want to cut into it.
I understand that. In order for the plaintiffs here to submit a plan to EPA for their approval, they have to be considered potentially responsible parties, don't they?
That's correct.
To comply under 122. And if they're not responsible parties or potential responsible parties, 122 does not apply, correct?
Right. The key is the distinction between potentially responsible parties and responsible parties. And the reason that's a key is because CERCLA defines potentially responsible parties in Section 107A. And potentially responsible parties include landowners. The purpose of these statutory provisions is to ensure that EPA can coordinate a cleanup. It's not to encourage litigation in the first instance. EPA is not required to litigate and determine liability before someone is compelled to submit a cleanup plan. The idea is every Superfund site is a site. The site is on land. Sometimes there's dozens of landowners. Sometimes there's hundreds of landowners. If those dozens or hundreds of landowners need to have a final liability determination before EPA can review their plan, EPA's ability to coordinate these cleanups is completely undermined. That is why 122E6 specifically states that potentially liable parties need to submit their plan.
So
The fact
Mr.
that they
Oaks,
may be liable is enough.
before you sit down, you said there's a tiered process and you didn't get any farther than the 122E6 submission of the plan. Do you want to just finish up that thought of your tiered process, or have you said all you need to say?
Yeah, so 122E6, EPA needs an opportunity to review these plans. And then the second tier is whether this particular restoration plan is a challenge. And there's aspects of this that I think wouldn't be a challenge, but there's aspects that I believe would. And if the aspects that are not a challenge were the sole portion of the proposed restoration plan, we wouldn't have a problem.
So, counsel, and I appreciate you're on borrowed time here, but just as a clarification then, once EPA's work is done, and I understand there's a dispute as to whether it's done already or whether it may be going on to 2025, what interest then does EPA have in, say, one of these homeowners wants to just say, for my own peace of mind, I want to remove the top 2 feet, if once everything EPA is completely out of the picture?
I will say the analysis changes once EPA is done, and we estimate that we'll be done with the community soils portion of the ROD by 2022. The reason that's not a precise date is it depends on sampling and people bringing themselves into the process. And the reason that it could potentially change is if EPA is not actively in the site and they've ensured that their cleanup has been implemented according to their plan. In other words, the most hazardous stuff has been removed, the threat to human health and the environment has been minimized. Then, there's subsequent plans proposed by landowners go through a different analysis. That analysis still should go through EPA under 122E6, or it could go through the development permit process that allows for soil removal. And that's part of the record of decision that's been implemented. So there's different ways to do this, but it is a different analysis, and EPA should have an opportunity to review that. And, frankly, if there's a different cleanup might be something that EPA could authorize. If there are no further questions, I'll...
Thank you.
Thank you.
Mr. Stelpus.
Thank you, Justice Baker, members of the court. I want to start by departing from what I had planned to say and address some of the issues that have been brought up here, because typically when we come up on appeal, the record isn't developed in oral argument as we're sitting here arguing to you. Judge BIDEGARAY was presented with all of the evidence in the case. This case has been pending now next week for 9 years. Plaintiff's restoration plan has been developed for years, and ARCO and EPA have been working closely in this case. In fact, EPA helped prepare ARCO's expert witness reports in this case. Yet, here we are at this stage on appeal, where we were taken from a month before trial, and still at that point there was no admissible evidence in the record that anything about the plaintiff's restoration plan would conflict with the EPA selected remedy. We have argument from counsel in Amicus brief, but of course the statements of counsel are not evidence. And statements snipped from an ROD that, as we just heard, was not a review of the plaintiff's restoration plan, not only is not admissible evidence, but it's nowhere close to admissible, because following the Sunburst case, Judge BIDEGARAY excluded all evidence related to the CERCLA cleanup from our case in chief on restoration damages.
Counsel, has the landowner's proposed remedial plan been considered in the context of CERCLA and the EPA oversight? Not in the context of these legal proceedings, but in that context.
I'm glad that you asked that, because the answer is we haven't submitted it formally through whatever process there may be with the EPA, because that process is applicable to potentially responsible parties. And in 35 years, not a single one of our plaintiffs have ever been notified that they may be potentially responsible for CERCLA cleanup costs on site.
Well, counsel, doesn't 107A include landowners as PRPs?
107A does, but 107A is not the definition of potentially responsible party. They keep saying that it is, but it's a statute entitled covered persons. The statute covers owners of a facility, but that is the definition of covered persons. If I were to analogize, it's sort of the potentially responsible. These are the type of people that may be brought in to a CERCLA proceeding. But, and I want to highlight for the court the Fourth Circuit's analysis on this and the Fifth Circuit's analysis on this, because it's very important as to the proper analysis to determine who is a potentially responsible party.
Can we have your case cites?
Absolutely. In OHM Remediation Services versus Evans, it's from the Fifth Circuit, 116 F 3rd 1574 at pinpoint site 1582. Potentially responsible party is not defined in the statute. However, the most sensible reading demands that a party may be potentially liable simply by being sued under the statute. In the Fourth Circuit, at Pneumo Abex versus High Point, 142 F 3rd 769 at footnote 2, states, while CERCLA does not define potentially responsible party, the courts have understood it to refer to a party who may be who may be covered by the statute at the time that said party is sued under the statute. And the closest case we have to analogizing the situation we have here is in the Taylor Farms versus Viacom case. And in that case, a polluter was alleging that the plaintiff who sought restoration damages beyond that required by CERCLA was a PRP. But the court held that no case has ever declared that an erstwhile plaintiff who has never been the subject of prior action under CERCLA, has never entered into a settlement with the EPA, has not been found to have actually contributed to the contamination, has been declared a potentially responsible party. And that makes sense. 122E6 was designed to prevent someone who actually may be responsible for these response costs from changing the site by preempting the remedy that may be selected later on by the EPA during the remedial investigation phase. It makes sense not to allow somebody who's responsible for the costs to go in and take action that can change the site. But it doesn't prevent Mr. Phillips, who I saw here earlier, from putting in a garden. And it doesn't prevent these people from excluding ARCO or their waste from their property. And as this court recognized in Sunburst, to limit or eliminate the possibility of recovering restoration damages would equip a tortfeasor with the equivalent right of a private right of eminent domain. In other words, they're forcing these people to house contaminant waste on their property forever and always, is ARCO's position here.
Counsel, let's just assume for a minute that we rule in your favor and you go to trial and you recover restoration damages and it goes into a trust. Is it the expectation of the landowners that that trust, whoever the trustee is, would coordinate with EPA so that there's a coordination going on between EPA and the trust in terms of the cleanup of the continuing cleanup of their property?
We have no problem coordinating with the EPA. The EPA has known about our case for years. There's no legal requirement in the law for us to do so. And the EPA has never said, hey, you're a PRP, so you have to run these kind of things by us if you want to do it. That's the notification process. But we'd be happy to do so.
Of course. Has the government filed any kind of a pleading, either in state or federal court, to declare your clients in this case to be potentially responsible parties?
The only such pleading that could possibly be construed as such is the amicus brief in this case, which I want to point out differs from the amicus brief.
No, I'm not talking about briefing. I'm talking about taking an action to have a court declare the landowners here potentially responsible parties.
No, heavens no. And I want to bring up that Section 122 that we're talking about requires, and it makes sense, notification to all PRPs at any settlement discussions that are related to the cleanup that's going to be ongoing. And that makes sense, right? The people that could be held responsible under 107 should have a right to be at the table for those talks. But to the contrary, EPA and ARCO have sealed those proceedings to not only our clients, but to the public in general. So they don't have a place at the table even for that.
So if the EPA has not been, I guess I'm having some issues with how you deal with the reasonable abatability analysis and CERCLA controlling the EPA's actions and how that interjects or how that's considered in assessing whether the injury is permanent or temporary. That was a hard question, I know, but it's a hard answer.
It is a hard question, and luckily I don't have to answer it because you have. The answer is in Sunburst. And in Sunburst, the court specifically stated that restoration costs may be awarded if an injury is temporary, citing the Burke Ranches case. And then the court went on to say that a temporary injury may be abated or discontinued at any time, either by the acts of the wrongdoer or by the injured party. And in this case, the plaintiffs have a constitutionally protected right to clean up their own property, and to afford that right, the plaintiffs have a remedy at common law, which is restoration damages. And neither EPA acting alone or in conjunction with ARCO can deprive the plaintiffs of that constitutional right.
But EPA is controlled by the remedial plan it follows under CERCLA. It can't do more than what CERCLA authorizes it to do. Is that correct?
Well, not necessarily either, but I get the point of your question, and I'll get to that. But I do want to address, can ARCO do more? And in rereading your decision in Christian, in paragraphs 39 and 40, there's a recount of the types of things that ARCO has offered to do in order to minimize its own liability that go beyond what the EPA has required. For example, this pasture property discussion that we had. Mr. Rauschwey said that, well, on pasture properties, they want to go beyond it. Pasture properties are defined as anything that's further than 125 feet from their homes. Well, ARCO has cleaned up beyond the 1,000 part per million action level on pasture properties. And they will, of course, say, I'm sure, that EPA gave us permission to do so. We're not entitled to see those negotiations, but certainly ARCO has agreed to go beyond what the ROD is required. And in fact, they do in this case. As far as the groundwater remedy goes, they say, hey, we have an idea. Why don't you let the plaintiffs put in a gravity drain, which will, in effect, dilute that top portion of the aquifer. And that's much cheaper than actually cleaning up the arsenic to dilute it. So they're offering, and they're suggesting that the jury do something more. So no, I don't believe that they're bound by that. But I think the point of your question was, was the contamination reasonably abatable, considering ARCO, as I'm sure they will say, was prohibited from doing more than the EPA could do. Does that get to the...
Yes.
Yes. And the answer is yes. Of course, reasonable abatability in this state requires that either the polluter or the landowner could take action to remedy the contamination. And that's an additional onus on the plaintiffs that we have in this different scheme of common law restoration damages that doesn't apply to a CERCLA action, right? So can the plaintiffs do it? Well, that's a question of fact for the jury that we need to prove. But ARCO is being punished in this case, or held responsible for its active pollution. And that's what really is at issue here. They had a trespass, and they continue to trespass, even after the EPA selected cleanup, which I want to make the point has finished on the plaintiff's properties. As far as the plaintiffs go, no additional cleanup plan is contemplated.
Counsel, when you're talking about being held responsible for the trespass, et cetera, those
Yes.
are not an issue here. I mean, there's no argument that the claims for trespass, nuisance, diminution in value, those are not preempted, correct?
Well, those particular damage claims, but as this court held in Sunburst, the only way to fully compensate a property owner for an ongoing trespass and nuisance, if they want to keep the property rather than sell it, is restoration damages, to exclude that polluter and their waste from their property. So while certain damages that this court has said are inadequate and would grant to ARCO a private right of eminent domain are still collectible. For the tort of trespass, the plaintiffs have a remedy at common law, which is to remove that trespass and to end it and remove that contamination from their property.
Can you address the argument that was made both by ARCO and the government that the plaintiffs' plans, both for soils and groundwater, well, and especially, I guess, for soils, would actually undo some of the remedial actions that the EPA has been working on for all these years?
Be happy to. This isn't for lawyers to argue what's going to happen out there. This is for technical experts to answer as far as how they're going to avoid undoing something.
Yeah, and I guess that also gets into the questions you've heard today about where do those factual disputes properly come into play in this case?
Sure. So the plaintiffs submitted unrebutted expert testimony from their expert John Kane, who's a hydrogeologist and the engineer of the cleanup plan. In 2000, when we filed this case, the cleanup had only applied on 2 properties, but then during the course of litigation, as is common in these cases, the polluter will do more cleanup. Now they've finished now officially, but after ARCO completed cleanup in 2016, when we had those plans and we sent it to John Kane and we said, make sure we don't undo this. Take into account what is happening here so they're not responsible for the cost and for double recovery, which is prohibited through CERCLA, and write an expert report. So he did. And we provided that to ARCO in accordance with the court's scheduling order. And there was no retort, so to speak, that creates a material issue, a genuine issue of material fact as to whether or not that was appropriate. All we've heard are legal arguments, and this one about undoing stuff for the first time literally here today at oral argument, not even raised in the briefing. So the court has a process for making sure that we're allowed to cross-examine experts and determine whether or not they actually have a basis to say what they say and exclude those experts if necessary. We've been deprived of that. If the court were to say there is a genuine issue of material fact raised by the statements of counsel at oral argument.
Well, counsel, I understand your argument, and I know you're going to run out of time here. I mean, we're dealing with the main issue here is CERCLA preemption. We're dealing with Section 113 and Section 122. Do you want to deal with those specifically?
Yes. So after CERCLA was passed, there were various dilatory lawsuits that arose that were frustrating one of Congress's principal purposes, which was the prompt remediation of property. So Congress in 1986 passed Section 113H, which was passed to ensure that cleanup was not slowed by litigation.
Well, counsel, excuse me, I want to cut to quick on that question if we can. Your assertion in your briefing, and I challenged ARCO's counsel about this, is essentially this federal authority that says that a challenge, impermissible challenge, is one that will alter, delay, or stop an EPA-selected remedy. That's right at the heart of what your position is it not? That's the threshold for an impermissible challenge?
Yes.
Now, counsel from ARCO, out of hand, dismisses that characterization as being too narrow. What do you have to say about that?
Well,
they say that in response to my question today and in the briefing, that that's too narrow of a focus, and a challenge can be broader than that as a matter of law.
Well,
an impermissible challenge.
I don't want to argue the case for Mr. Rauschway, but what I saw in his briefing was...
Tell me why it's wrong.
Well, because that is what Congress set out to prevent, was challenges that would delay, alter, or interfere with the cleanup. And that's the common theme in all of the cases that they cite in their brief. So we know that certain types of cases, polluter challenges, are prohibited. That's the resort case, which has the relate to the goals of cleanup language that I'll discuss in a minute. So if a polluter says that they want to do less, that interferes with the goals and it would delay it in litigation. That's prohibited until afterwards. Citizen suits. Now this is primarily what ARCO relies upon. Citizen suits which seek to improve upon the goals of the EPA cleanup that the EPA will be enforcing upon PRPs at the site. This isn't one of those cases. We're going to do something different than, we're not asking the EPA to change anything. So I think your interpretation is exactly right. If you look at the facts of every case, they turn on whether the lawsuit, the damage claim in the lawsuit, would alter, interfere with, or delay the EPA cleanup. Now, New Mexico versus General Electric was brought up, and it's been brought up in the briefing. And I want to talk about why that case is not on all fours with this case. And that's very important. First, New Mexico did not identify any residual contamination that would exist after the completion of the EPA selected remedy. Now, the evidence in that case, and the experts determined that, well, first, the EPA plan in that case, let me describe that. The EPA plan in that case was to address the entirety of the contamination, all PCBs, in that aquifer. And all of the evidence in that case demonstrated that's exactly what was happening. Now, New Mexico did not seek restoration damages, like the plaintiffs do here. Instead, they sought an unrestricted sum of money that would go into the state's general treasury fund, and it was $4 billion in that case. But it explicitly stated it wouldn't be using those, wouldn't be earmarking those funds for restoration damages because it couldn't identify any residual contamination. And the court, in fact, stated that CERCLA sets the floor for environmental cleanup, not the ceiling. And that's a principle that has permeated through all of the cases that have examined Section 113H, or CERCLA in general, such as the bar on double recovery. CERCLA was designed to act in conjunction with state law remedies to effectuate cleanup. And that's why we have the bar on double recovery. The bar on double recovery, Section 114B in CERCLA, states that if a plaintiff or if a person collects damages through some other state remedy, that they're prohibited from recovering that same remedy through a CERCLA action. It's the bar on double recovery. Now, as Stanton Road and the Ninth Circuit determined, and as the Manor Care versus Yaskin case determined, if you interpret CERCLA, as ARCO does, to preempt state common law claims for restoration damages, or any claim seeking restoration or repair damages, then Section 114's bar on double recovery makes no sense at all. And certainly, when we're interpreting CERCLA, we want to give effect to every provision within CERCLA. So, getting to your question, I think Beck versus ARCO is a wonderful example of the type of case that doesn't interfere with CERCLA. And I'll finish this thought. So, in Beck versus ARCO, the court determined that so long as the damage claim does not alter the terms of the cleanup, then the claim is not a challenge and may proceed. And that's exactly what's happening here. The goals of the EPA cleanup are to remove portions of yards where the soil concentration of arsenic exceeds 250 parts per million or 400 parts per million lead. In effect, what they're doing is cleaning up hot spots. This is exactly the case in the Taylor Farms versus Viacom case. In Taylor Farms versus Viacom, the EPA was cleaning up certain hot spots that it identified by a certain action level. Taylor wanted Viacom to pay for the removal of all the contamination. And the court held that about the only sense in which Taylor's lawsuit can be said to challenge Viacom's settlement with the EPA is that if Taylor is successful, Viacom will be required to spend more money to clean up the land for Taylor's benefit than the EPA required Viacom to spend for the public's benefit. Well, the court finds that that is not enough to bar the claim. The language of CERCLA provides no such sweeping immunity. And I also want to highlight this court's decision in Sunburst, analyzing a sister statute to CERCLA that is based on many of the same principles. Government-selected cleanup standards, as this court observed in Sunburst, are different than and irrelevant to a plaintiff's claim for restoration damages. A plaintiff's claim that would seek to remove a polluter and their waste from their property. Now, a common law cause of action has various burdens that a CERCLA action wouldn't. We don't have, we have to require reasonable abatability. We have to go before a jury. But these are two separate systems that Congress designed CERCLA to accommodate. It wanted to protect its remedies by preventing any alteration or delay of the cleanup, but it did not seek to preempt common law causes of action that likewise would clean up the property.
Counsel, is there any follow-up on Viacom? That's a federal district court case. Is there any other authority beyond that?
There certainly is. Every case that has examined this particular issue has allowed these types of cases to go forward. So, New Mexico versus Minnesota mining. Now, in that case, the plaintiff state sought restoration damages that would go beyond the EPA selected cleanup. And the defendant in that case argued, well, you are seeking to improve upon the remedy by doing more than the EPA remedies required. Therefore, this case is federal, right? Because all challenges to a CERCLA remedy, according to Section 113B, are exclusively federal in nature. So that was a removal action, right? And the court determined, no, that's not the case. These two systems were designed to act in conjunction with each other. And the case doesn't specifically cite 113H, but it does discuss Section 113B and challenges to a CERCLA remedy. That's exactly what the factual situation is exactly similar. Bernie Samples is another case where a plaintiff was allowed to recover damages. Granted, there's no requirement under Florida law that the damages actually be used for cleanup, but I would assume that if you're going to a jury would impose that sort of requirement on
Counsel, what would happen to, let's say for the sake of argument, that you are allowed to argue for and you recover restoration damages, and what is ultimately through the inner workings with the EPA, or just what ultimately ends up being the cost, what happens to the residue? Let's say you recover more in restoration damages than what actually you spend or are allowed to spend. What happens to the remainder of that trust, I guess, in terms of, since the idea behind it when we adopted the restatement in Sunburst is to prevent a windfall. So what would happen to that?
Sure. Well, of course, the remedy would be designed to make sure that we don't overshoot, but such as in Sunburst, for example, there is some residual money remaining in the trust that remains to address any future contamination that might arise. I mean, this very thing is ongoing. The Sunburst case led to a wonderful cleanup in that community. So it would be retained by the trust to continue monitoring and make sure that everything goes as planned.
Thank you, Mr. Cossey. Mr. Cossey. Mr. Smith, can you tell us how much time he has? You have 5 minutes.
That should be sufficient, depending on questions, of course. Thank you, Acting Chief Justice Baker and members of the court, for allowing the MTLA and MEIC to weigh in on this important issue. I'd like to read you a quote from the EPA's brief to the United States Supreme Court in CTS Corp v. Waldberger, a case in which the EPA argued against preemption under CERCLA. The careful attention Congress paid to not preempting state law, except in one narrow respect, makes it proper to resolve any ambiguity in Section 9658 against preemption. This was just 4 years ago, and the EPA was arguing to the United States Supreme Court that even an express preemption provision of CERCLA must be interpreted narrowly. It stressed that Congress was very careful to not preempt state law under CERCLA. In Waldberger, the EPA joined as amicus in a case over the interpretation of 42 U.S.C. 9568. That statute extends the discovery doctrine nationwide for any state law action involving pollution, so that landowners will not be barred by a state statute of limitations if they did not know of latent or migrating pollution within their land. Besides the fact that the EPA is taking inconsistent positions on the breadth of preemption under CERCLA, let's examine what 42 U.S.C. 9568 means. It means that Congress actually did think about preemption when it was passing CERCLA. And it passed exactly one preemption statute that expanded state law remedies, or at least access to them. Now, why would Congress explicitly expand access to state law remedies for pollution and then at the same time preempt those remedies? It doesn't make any sense. This is especially true given the explicit reservation of state law remedies additional to CERCLA elsewhere in CERCLA, such as the language of 42 U.S.C. 9562 and 9614, as the EPA recognized in Waldberger. Notably, the only consistent position that the EPA has between Waldberger in this case is that they are on the side of a corporate polluter. ARCO and the EPA now urge a preemption doctrine not only clearly contrary to Congress's intent, but one that also runs afoul of the United States Constitution. In the Red v. Teleprompter Manhattan CATV Court, the United States Supreme Court held that even a minor but permanent occupation of land under government authority constitutes a taking. Here, ARCO and the EPA argue that CERCLA should allow ARCO to permanently house tons and tons of arsenic and other heavy metals on plaintiffs' lands under government authority.
Is there a takings claim involved in this case?
There's not, and no eminent domain claim has been brought by the government either. I would, of course, defer to them on that. In Montana, the presence of pollution is an occupation of land, as this court has held multiple times, such as in Sunburst and in Christian 1. As this court stated in Sunburst, a strict cap on restoration damages would equip the tortfeasor with the equivalent of a private right of inverse condemnation, or a power akin to a private right of eminent domain. Because Montana landowners have the right to exclude or remove the pollution of others from their properties, an interpretation of CERCLA that forces private property owners to store the pollution of others would result in a taking without due process, violating the Fifth Amendment to the United States Constitution. Now, a court must interpret statutes in a manner consistent with this Constitution, and luckily, it is clear both from the cases that plaintiffs cite and the text of CERCLA, when you read it as a whole, that CERCLA does not prevent state law remedies additional to CERCLA remedies, and no conflict between CERCLA and the Fifth Amendment exists. On behalf of Montana landowners and other interested parties, we strongly urge the court to adopt a constitutional interpretation of CERCLA, one that was clearly intended by Congress, that landowners on Superfund sites maintain their state law remedies to exclude others' pollution from their land. Thank you.
Thank you. Mr. Rauschwait. 3 minutes?
3 minutes, all right. I'll be concise. We have 3 separate arguments here, and they've been conflated a little bit in my opponent's argument, so I want to make sure that we address each one of them separately. There's the 2 statutory arguments, 113 and 122, and then there's a separate conflict preemption argument.
Counsel, before you, and I know your time is limited, but before you get to that, we haven't really talked about 9652. And I understand some of the case law that has interpreted it, but just as a matter, again, as from a matter of statutory interpretation, sub D is nothing in this chapter shall affect or modify in any way the obligations or liabilities of any person under other federal or state law, including common law. How is what you're arguing not seeking to modify or affect the obligations that might otherwise be imposed upon ARCO under state common law?
Sure. Justice Shea, that's a general savings clause. The Supreme Court has recognized over and over again that a general savings clause does not prevent a statute from having conflict preemptive effect or even express preemptive effect. I mean, if that savings clause meant what the plaintiffs in this case are saying it would mean, then the Waldberger case that Mr. Crossie just talked about wouldn't be able to affect express preemption. So no one is arguing that the statute is a generally preemptive statute, that it preempts the field of state law. We're not saying that that would be wrong. But it does expressly preempt certain things. We're also not arguing that here, but that's what was at issue with Waldberger. Our argument here on the preemption side is conflict preemption. And at least 4 circuit courts have held that CERCLA does prevent...
And I apologize, but in terms of the conflict preemption, the conflict is because of what they are saying they want to do that EPA may or may not allow them to do with the restoration damages. And go back to what I asked Mr. Stalps and you. If it's put in trust and there's no issue of them getting a windfall, then there's no question if it's put in trust also if their genuine intent under the personal reasons element, then why isn't that just the solution? And then there's no conflict because it'll only be spent on restoration once they work with EPA.
That doesn't address the conflict under conflict preemption. I think the trust issue has its own problems related to allowing a speculative damage recovery based on the notion that at some point in the future this cleanup might actually be able to be performed. But the conflict for the purposes of conflict preemption are the manifestly clear goals that Congress had in enacting and reauthorizing CERCLA. And again, this argument applies even if the court decides for whatever reason that sections 113 and 122 don't apply to the plaintiff's restoration damages claim. But there can't be any real dispute here that Congress intended EPA to be the one to determine remedies at Superfund sites, not the expert witness that plaintiffs have hired in this case. And that's important not just for this case, but for future cases. If this claim is allowed to go forward, we might have additional lawsuits and have 5 different cleanups going on at the site at the same time. So that was clearly an intent of Congress in passing CERCLA. Congress also intended to protect EPA's chosen remedies from interference while they were being implemented, either from lawsuits or from on-the-ground remedial action. That goal would also be thwarted if this claim is allowed to go forward. And finally, Congress outlined a very detailed but limited role for the public to participate in the selection of Superfund remedies. On the front end, during the 5-year review process, on the back end, and then finally when complete through a citizen suit. All of those provisions would be completely negated if plaintiffs could simply go into state court and try to convince a jury that they should be able to perform whatever remedy they want.
Your time is up, Mr. Rochway. Does anybody have further questions? All right, do you have a final concluding thought since Justice Shea asked at least a minute of questions? So I'll give you a final concluding.
I have lots of concluding thoughts, but I will be disciplined. To put this a little bit into perspective, even the state could not do what the plaintiffs are trying to do here. There's no reason to believe the state would want to do that because they concurred in both of these remedies. But CERCLA would not even allow a state to perform an alternative remedy. There is a provision in CERCLA, Section 121, and implementing regulations that provide exactly what happens if a state believes that a Superfund remedy is not sufficiently protected, and how it can go to EPA, and if it can convince EPA that it's correct, that the remedy needs to be modified to be more protective, EPA will do that. The second layer is EPA decides if what the state proposes to do would conflict with EPA's remedy. And if they decide it conflicts, the state can't do it. If they decide it doesn't conflict but is not necessary, they will allow the state to do it. So this is a process that's built into the statute, into the regulations. And if the state could not do what the plaintiffs are trying to do here, how could it possibly be that private citizens could do that through a jury award? Thank you, Your Honor.
Thank you. Thank you to all counsel for your fine arguments. The case will now be submitted and the court will issue a decision in due course. And thank you all for attending today. I hope you found it interesting. We're adjourned.